purchased using a stolen credit card. The laptop was searched without a warrant. Officers found child pornography on the laptop, and then there was a challenge to the search of the laptop. The Ninth Circuit held that because, as the district court below found, Kamen obtained the laptop computer by fraud, he had no legitimate expectation of privacy in the contents of the hard drive. We see no ground on which to distinguish property obtained by fraud from property that was stolen by robbery or trespass. And so if you see here, I'm kind of building how this goes from stolen vehicles, trespass, fraud. The courts are treating them all the same way. I also want to touch on another federal case, United States versus Johnson, 584 F3rd 995 at 996. This is a 2009 10th Circuit case. It deals with the search of a storage unit that was rented out using through identity fraud, so using someone else's information to rent out a storage unit. And I'm going to read a block quote from that case. The court said, ultimately, what matters is not whether Johnson might have some legitimate property interest in the storage unit, but whether Johnson's interest is one that the Fourth Amendment is intended to protect. Arguments such as those Johnson advances here do not distract us from the fact that a fraud was perpetrated and the victim was a third party. We will not be a party to this fraud by legitimizing Johnson's interest in the storage unit. Therefore, whatever subjective privacy expectation Johnson had in the storage unit were not expectations that society is prepared to recognize as objectively reasonable. Johnson thus did not have any Fourth Amendment rights in the unit and could not expect that the police were required to obtain a warrant or establish an exception to that requirement in order to search the unit. And so, kind of moving to the facts of this case, Judge, I'm going to share on the screen just a little illustration and timeline, because there's